Court's now in session. We may be seated.
SJC-13105, Matthew Sachs v. Nancy Dissinger.
Attorney Hamer.
Good morning. Please support Robert Hamer, plaintiffs Matthew and Rebecca Sachs. The issue before the court involves construction of General Law, Chapter 203E, Section 604, which provides the person may commence a judicial proceeding to contest the validity of a trust that was revocable at the settler's death within 1 year of the settler's death or 60 days of receiving notice.
So is it your position that it's a statute of limitation or a statute of repose, or does it not matter for your client?
My position is it does not matter for purposes of my client in this case, but I think if it comes to that in the end, it makes sense that it be treated as a statute of repose, noting, however, that it does not include the language of classic statutes of repose in the Commonwealth, which include language like in 260, Section 2B, in no event. So where there's a statute of repose, it's unequivocal. For that matter, where there's a statute of limitation, the limitation is stated in the affirmative using language such as that in throughout Chapter 260 shall be commenced only, rather than the permissive may commence.
But your position is that unjust enrichment and intentional interference with advantageous relationships, there's no statute of limitations problem.
Not under this section. They are addressed in Chapter 260 and not by this provision that deals only with proceedings contesting the validity of the trust, as indicated in the comments of the National Conference of Commissioners in preparing this Uniform Act. A contest is an action to invalidate all or part of the terms of the trust or if property transfers to the trustee. And they specifically state in drafting this proposed uniform statute, which was adopted in this regard by the Massachusetts legislature without change, that an action against a beneficiary or other person for intentional interference with an inheritance or gift, not being a contest, is not subject to this section.
Counsel, let me ask you then, how do you get to your remedy without getting to the validity of the change in that you claim was made as a matter of undue influence? How do you get to the end without getting to the first part?
Well, actually, damages arise under the plaintiff's claims only upon enforcement of the trust. Mm-hmm. So if the trust is revoked, there would be no damage. Upon enforcement of the trust as amended, mm-hmm. damages accrue. And that is the final element of each of the common law claims raised by the plaintiff. So the plaintiff's claims rely upon the enforcement of the trust as amended. Without that, there are no damages. Mm-hmm. So that's the approach. It's dependent upon the enforcement of the trust as amended. Without that, there are no damages for intentional interference, and there's no unjust enrichment. So
Well, counsel, if I assume that I'm going to that the dismissal of the complaint against the trust to rescind the trust or change the terms, if I assume that's out, then the trust is going to be enforced, right?
Yes.
So why are there not going to be damages then that they could file a suit on?
Well, I think there will be damages. That is the allegation. There will be damages. The point for present purposes in examining the lower court's action is that those claims are not a proceeding to contest the validity of the trust. There are claims for common law damages.
Okay. I think I might not have understood what you were talking about before, so I think I get it now.
The substance of the action's the same, isn't it? I mean, I'm trying to understand the difference between if you're trying to rescind it because there was undue influence and you're trying to sue after because there's undue influence, isn't the substance exactly the same? It's just you're allowing it to be enforced. And then, so you could have brought the other claim, right? Challenging, if you could bring a timely claim, you could bring a claim to challenge the enforcement of the trust, right?
Yes.
And that claim is exactly the same as the one you're bringing later. It's just you're allowing the trust to be executed, right?
It's not the same.
Why isn't it the same? Because isn't the substance of the argument exactly the same, that there was undue influence and therefore it resulted in a different beneficiary?
Well, the evidence of undue influence would be the same, but that doesn't make the causes of action the same.
Isn't what you have to prove exactly the same too? How would proving the one that tries to blow up the trust be different from proving the tortious interference or the unjust enrichment? How would it be different?
Well, taking the interference claim, and I would draw the court's attention to the elements of intentional interferences as stated in Blackstone and Cashman, 448, Mass 255. The element that we're addressing through that question, Your Honor, is the defendant proving that the defendant's interference with a relationship, in addition to being intentional, was improper in means or motive, which is different than whether there was undue influence getting into the settlor's free will. It is a different standard of proof, a different element of proof. It involves some of the same evidence, but it's fundamentally different in that an intentional interference claim doesn't rely on undue influence in the same sense of absence of testamentary intent and that sort of thing. It's the defendant's interference with the relationship being improper in motive or means. So it's the classic tort claim of interference that doesn't hinge solely on an undue influence.
And is there another difference that the action to rescind a trust would be an action in rem, that is as against the trust, whereas an action regarding intentional interference is something against the person who intentionally interfered?
Absolutely, Your Honor.
And don't we legally treat those as different, even if the underlying story is the same? Exactly.
And there's no claim here against the trustee for any reformation or anything like that. It's strictly the kind of third-party claim that was expressly accepted out in the Uniform Committee's comment with regard to same.
So I understand that as it relates to the intentional interference, because that gets to Nancy and the grandmother poisoning the well and having the assets eventually be divided in 4 as opposed to 5. And it goes to conduct before the trust was actually redrafted. And it doesn't have anything to do with challenging the manner of execution or anything like that. But the unjust enrichment that involves all the aunts, and it's trying to change what the distribution that's called for under the trust would be. So why isn't the unjust enrichment fall within the concerns of a contest and the 1-year statute of repose or limitation?
It is a closer claim, granted, but it falls within the same distinction, I think, of whether the claim brought is one in rem or against the persons, the defendants, for damage remedies. So I think that's a fundamental line that can be drawn between the claims that seem to be addressed by the statute, whatever it's attempting to do with regard to the rem of the trust and its enforcement and damages against third parties on common law theories, which are more directly addressed under the statutes in Chapter 260.
Is there any explanation of that comment besides you've listed the sentence or two that's in the comment. Is there anything more do they explain the reasoning in that comment? I haven't gone back to the comment.
I've seen, Your Honor.
Is there any commentary on the comment out there?
Not that I've seen other than what I'm attempting to provide today.
Okay.
Nothing written.
So why is Michigan, Missouri, DC, and Judge Feely wrong?
I think on a plain language basis, the statute means what it says. Apart from the kind of rather concerning permissive language that is adopted here in contrast to the recognized statutes of limitation in the Commonwealth, this is not a claim that involves the validity of the trust for the reasons that have been argued. So it's wrong because it kind of jumps to the conclusion without looking at the points in between as far as how to get there. This is not, and those were not entirely actions to assert the validity of the trust, but damages for common law claims or claims for damages on common law theories. I would highlight to the court not only the distinction in the language used in Section 604, the permissive language, contrasting it with both recognized statutes of limitation and statutes of repose, and reflect on the difference and what meaning should be attributed to the difference in the language chosen between the permissive and the definitive. Looked at more broadly, I've reflected on the court citation last year in D'Alessandro to kind of the general rule of statutory construction, citing Galensky and Irving, that a statute must be interpreted according to the intent of the legislature ascertained from its words, construed by the ordinary and approved usage of the language. We've been through that in our discussion. Considered in connection with the cause of its enactment, the mischief or imperfection to be remedied, and the main object to be accomplished to the end that the purpose of the framers may be effectuated. The question then, looking at the statute more broadly, and again, my contention is that the statute has no application to the common law claims for damages, but looked at more broadly, what is the main object of Section 604? The main object, and I suggest this, and I don't have any reading or comments to cite the court to, but the main object, when you look at the statute as a whole, and we've only focused on paragraph A1, it goes on through paragraph C. But the main object, I would suggest, appears to be to provide certainty in trust administration and limit the liability of the trustee only, for distribution of trust assets. Interestingly, paragraph A2, we've been talking about A1, paragraph A2 establishes something kind of unique in that it's a statutory option for settlor's amendment of a contested trust following notice. If someone elects to provide notice of an amendment or a revocable trust, there's a 60-day clock that runs, which would create the certainty in administration of allowing a settlor to address something raised. That seems to be a main object to be accomplished through this. The balance, paragraph B, addresses the liability or limits of liability of the trustee, only the trustee. Paragraph C is the only provision that concerns liability of persons other than trustees in the statute, and that is not a limitation of liability, but an expansion of liability. Paragraph C provides that a beneficiary of a trust that is determined to have been invalid shall be liable to return any distribution received, apparently regardless of whether the trustee was liable under paragraph B. Nothing earth-shaking about that, but it is noteworthy in that that is the only part of this paragraph, or the only part of this statute, section 604, that purports to address liability in any way, and that is not as a limitation of liability, but only as an affirmative statement that there is liability.
When's the earliest your clients could have known what was going on?
Could have known. Given the family dynamic, Your Honor, I'm not sure of when they could have known as a practical matter. I can't answer that.
How about as a legal matter? When is it that they could have known?
Well, I mean,
when there was a probate?
Looked in the broadest sense, they could have known if someone told them after it had been changed. So revocable trusts are kind of inherently private, unless.
Yeah, but Nancy doesn't want to let them know. So when is it? When would they be able to know? When you have, because it went through probate, right? The house that was funding the trust?
I don't believe this went through probate because the assets went through the trust. So there was nothing, if my memory serves, and I would stand to be corrected, there was no probate estate for the settlor. His wife survived, and it was upon the wife's probate that this was discovered. That doesn't exactly answer the question, when could they have known, but that's when things came to a head. It was all the assets passed through the trust. There was no probate in this particular case. And this issue came to light upon her death.
Can I just ask one last question for me anyway? Subsection C that you just read, how do you square that with allowing an unjust enrichment claim out of time?
It doesn't purport to be the exclusive remedy. It provides that a circumstance where they are liable. It doesn't say anything about it being an exclusive remedy.
Any further questions? Thank you, Mr. Hamer.
Thank you.
Counsel?
Good morning or good afternoon. My name is Mark Marashi, and I represent the defendants, all of the sisters of that are all named as defendants in this matter. Can you talk a little louder? Okay. The one thing I want to clear up, one of the judges asked was when would the earliest they could have known. In the addendum in our brief is the Xerox of the probate proceeding of Aaron. So Aaron died in 2017 and the docket is there. So as an heir, the earliest they would have known would have been in the 2017 probate. If I may, Your Honors, this is an appeal from a decision of the Superior Court dismissing the claims asserted by the children of one of the siblings of Aaron Sachs, the two children of Matthew and Rebecca. The four defendants are sisters.
Counsel, can I ask you to specifically address the comment and the line in the comment that says that an action against a beneficiary for intentional interference not being a contest is not subject to this section?
Yes, I can. If you look at this, first of all, this isn't the statute. This is just a national organization that submitted something, and I didn't see it anywhere in the Massachusetts legislative history, but the prior sentence says a contest is an action to invalidate all or part of the trust. That is what's going on here. Despite the artful drafting, that if it's
Well,
not.
that was what's definitely was asked for in count one when they sought rescission, but they dropped that count.
Oh, the contest is all the other counts as well, because the remedy they're seeking, I mean, they're arguing a lot about damages, but if you look at the remedies they're seeking a rescission still of the amendment.
Well, that one's out.
Yeah. Well, that's the only way they can recover under the theory that they've.
Well, no, they can go after the ants for intentional interference.
They conceivably.
As a
they could,
standalone claim.
but the other aspect is that they're seeking an enforcement of the original trust. That's.
Well, but those, are you talking, counsel, about the actual pleading right now? Like what was complained in the pleading? So what relief was requested in the pleading?
There's 4 prayers for relief.
All right.
One is rescission.
Right.
That's in the amended complaint even, so that's still there. They haven't taken that out. The second is enforcement of the 2011 trust according to its terms. The third is to prevent the 4 sisters from recovering in excess of the 20% allocation toward the sisters in the 2011 trust. And then the fourth makes a claim indicating that just damages against Sheila and Nancy in the amount of their damages.
And wait, what about the damages?
Just as in the amount of their damages, but the damages all relate back and refer
All
to
right,
the trust.
but if I accept that, if we just say the count on rescission is out, so that takes out the first 3 prayers of relief, doesn't it? And leaves us with number 4? No?
Not necessarily, Your Honor.
No?
The gist of this claim, and then the cases show this, is that they have essentially taken a trust contest. And they're seeking to knock out the first portion, the amended trust, and they're seeking to enforce the underlying trust. The damages that they're seeking just happen to be identical to what would have been requested in the 2011 trust.
But this isn't the distinction without a difference though, right? Because if you go back to Justice Wendland's comment, assume that the rescission is an in rem proceeding, right? And so let's just say that that's out. And so now there's no cause of action or no claim against the trustee. And let's say the trustee then disperses the money the way that the trust was as amended. Okay. So now everybody's got arguably more than they would have if it were distributed the way it was, the way that the plaintiffs would like it to see. So now all the sisters now have the money, right? So now under their theory, that's now in personam, they will try to go and disgorge from the sisters what they received from the trustee. So isn't that a very different set of circumstances?
That subsection C relates to and if you ever read, you can't just read C in isolation. You have to look at the paragraphs before. That section states that if a trustee distributes the funds and it turns out to be an error, the beneficiary is liable not to the claimants. The beneficiary is liable back to the trustee because the argument is the trustee gave out these funds if they knew about a claim. If right now, if Ms. Dissinger had said, oh, I don't care about the claim, I'm going to cut checks to all my sisters. And if the claim prevails, they'll have to give me the money back. Good luck getting that money back.
Sure.
But the point of that C is if there's a distribution by the trustee, because the beneficiaries rely on the trustee. We can call it in person, call it in rem.
Yeah, but hold on for a second though. But let's just say that that's the case.
Mm-hmm.
And then it's fully vindicated and it's found that they should not have distributed the money to those beneficiaries. And now the money then in concept goes back to the trustee. What does the trustee do with it?
What's the trustee doing what?
With the money that's returned?
Go through the expense. If it was distributed in error, it would have to go through the expense of chasing each of her 3 sisters down and sending them a letter saying, please pay me the money.
No, I'm past that. It's been turned back. What does the trustee do with the money?
Would have to be subject to the decision of the court, whatever the court decides.
And conceivably, it could go to.
Conceivably, yes. But
right. Conceivably, it can go back to the children, right?
We're losing sight of one thing, though. This section 203 is the revocable trust is a modern, it's like a will substitute. What you're seeing more and more is that people create a will. The money upon death pours over into the trust. So if we are to look at the trust in the context of the estate administration, you're looking for clear language, you're looking for finality. If you allow the remedy that they're seeking, what you're telling these trusts, whether the trustee, whether the beneficiary, whether a co-trustee or otherwise, you're telling them you are at risk of a 3-year statute of limitations for tort, or you are at risk for a 6-year statute of limitation for contract. If a trustee came to me and said, what should I do? My suggestion would be, you have a risk of 3 years or 6 years to be sued.
The trustee doesn't, the beneficiaries
Of
do.
course has that risk.
No. The rescission's out. This is an in personam action against the beneficiaries of the trust. It's not the trustee.
Well, that's the artful way of paraphrasing.
Well, wait, artful, it's a complaint, isn't it, against them as individuals too, right?
There's a reason it's against them as individuals.
Right, because.
They knew they were past the 1-year deadline. That's the reason.
And also there's a count in there against them as individuals. And if you suppose they did not even bother with the trust, suppose the plaintiffs just said, forget the trust. I'm just really mad at my aunts. They interfered with my life. And so I'm suing them regardless of what, and I'm not even touching the trust. I didn't file anything about the trust. Wouldn't that complaint stand?
Not in the, no.
No, why not?
No, Your Honor. What they're trying to accomplish here, and the gist of the allegations are, it's phrased, excuse me, it's phrased well in the sense that, well, let's avoid the trust, let's sue the individual beneficiaries, one of which happens to be the trustee. Once that trustee, who's also a beneficiary, knows of the claim, she can't make any distributions because she's at risk.
Well, suppose they wait till after the distribution. She's still at risk, right?
Right.
She's at risk for her behavior with her relatives, not at risk because she's trustee.
No, I disagree with that. The claims, even though you say they're in personam, but the claim, the essence of the claims isn't the personal claim. It's essentially to knock out.
So then any
and
complaint,
disregard the trust.
and I want to make sure I totally get this trust area, any complaint that has in it somewhere, one of the defendants, there's a trust issue somewhere, but even though it's not pled, maybe it's a complaint again for contract or delivery of services, whatever it is. If there's some kind of underlying trust issue in there, it all has to be resolved through the trust?
But if the will, the way it's set up is everything pours into the will. And then from there, if you had a will contest, you could have to go into the probate court, make your claims within a year. And this is no different. All we're doing is we're taking the assets and transferring them from the probate court, shifting it over to the trust, and then letting the trustee make the distribution.
Yeah, that's not what I meant, but never mind.
So what do we,
We can't have a situation where.
can I
for
get
instance,
you,
190B, the claims against the personal representative. There's a 1-year limitations period there. So what you're saying is if I'm forming a trust and the trust then is, that becomes a subject of challenge, not to the trust, I'm going to sue the individual beneficiaries. You have now skirted the 1-year limitations period in probate court, and you skirted the 1-year limitations in 203E.
Yeah.
Every court, there haven't been many rulings on this, it's a relatively new statute, but every court in South Dakota, Missouri, and others that are cited in the brief, has found in our favor, and in favor of knocking out the trust and denying the claim. Denying the claims.
I get you on all of that. And I actually thought you were right, but I'm very bothered by the comment because the comment, you can't just dismiss the comment because they're the model drafters of the act who wrote that comment, right? They're not a bunch of, they're not some stray law review out there. They're the people who wrote this act. So tell me what they meant, because we adopt their act pretty much verbatim, don't we?
I believe we did, but if you look at
so we've got the authors of the act that we're adopting verbatim. The legislature is not a bunch of probate lawyers. We got to come to terms with this comment. So tell us what we do with it and why just ignoring it's not going to help.
Well, two things. One, you have to look at the statutory language first.
I've looked at the language, and your brother argues as follows. you're allowing the trust to go through the process. You're suing under a different cause of action, has different standards of proof. And again, I'm bothered by all the points you make, which is, it seems like we're just having the same fight without the statute of limitations and wiping out the statute of limitations. But it's just, the guys who wrote the act said this. So it's like weird, and I need help.
If I may, if you look at the sentence before, I think I mentioned this, I'll mention it again. It defines what a contest is. And that's precisely what's going on here, because in order to get to the beneficiaries, you have to have some decree stating.
I think the contest, the contest would. The contest, no, there is another way, because a contest is a term of art, but a lawsuit, a tortious interference claim, is not a contesting the will directly. It's a cause of action. It's different, right? I mean, it may be the exact same, and that's what's bothersome, but it's different semantically. So
along those lines, along Justice Kafker's lines, can you address the holding in Marshall versus Marshall from the U.S. Supreme Court and how they applied these concepts in that case?
Which case was this?
Marshall versus Marshall. It's from 2006.
I don't recall seeing that case in the.
Okay, that's one where the U.S. Supreme Court clarified the probate, what's called the probate exception to federal jurisdiction. They reversed the Ninth Circuit, where the Ninth Circuit had held basically that they could not bring a tort claim because it was too related to the trust. But the court said they reversed it and said the plaintiff's tortious interference claim is a widely recognized tort that does not involve the administration of an estate, probate of a will, or other purely probate matter. So they let that claim go through as unrelated. I don't see the difference.
Well, I haven't read the case, Your Honor, but I can tell you that the cases that we've cited in the brief and the Harvey versus Newman case, the one that we discovered just recently, also a Superior Court case, I believe touches on that. And if you look at the gist of what they're doing, which is the critical point here, the gist of what they're trying to do is invalidate the trust arguments and turn this into an action against the individual. The courts who analyzed Section 203, Chapter 203E, have rejected that proposition. And I'm asking that this court also reject that proposition and uphold the decision of the Superior Court dismissing the entire claims filed by the plaintiffs in this matter.
Thank you.
Any further questions? Thank you. Thank you, counsel.
Thank you.
All right. Hear ye, hear ye, hear ye. All present shall get in further the justices of the Supreme Judicial Court now sitting upon him within for the Commonwealth. At present apart, and give your attendance at this place Friday morning at 9 o'clock, to which time and place the sitting of this court is now adjourned. God save the Commonwealth of Massachusetts.